All right, I'm going to jump right in. Um, Please feel free to ask questions. I tried to put in mostly things that we run across the most frequently. So if there's any specific instances that you have questions on or want to talk through, definitely jump in. But like I said, I tried to just think of things that we do run across more frequently. Okay. First of all, we want to talk about the protected classes. Um, you cannot discriminate based on race, color, familial status, disability, sex, national origin or ancestry, religion, marital status, age, their lawful source of income, sexual orientation, or against domestic abuse, sexual assault, and stalking victims. So those are all things that you need to be mindful of. So this is just the license law as it pertains to us as realtors and real estate agents. Um, you cannot be treating a person unequally solely because of any of those definitions. So it's one of the statutes that we follow. One thing that comes up really frequently are love letters or dear seller letters. These can be tricky because based on information within the letter, they could create some sort of misrepresentation or a fair housing issue. You should never, as an agent, advocate for them to write a letter. Because that is a potential liability that could be avoided. You should not advise buyers what should be in a letter, and you should not offer any guidance as to what could be considered safe. Because if you do any of those things, then you're involved and you could get in trouble for violating fair housing. So here's another kind of adding some of our administrative codes into the mix. Any document written by one party during the course of a transaction, you need to, clearly tell your client the what it means to present those items. So that includes love letters, notices, offers, counteroffers, all of those things. So if it's any document that's made part of an offer does need to be presented to the seller. If a letter is not incorporated by reference, it may not be presented to the seller. Um, and a lot of agents have actually just kind of gone to that they just will not present letters just to avoid this issue in its entirety. So if you do need to present, you need to present in an unbiased manner to clients and customers. Something that we do see a lot is like MLS descriptions, social media descriptions, things like that, you want to paint the picture. So you write, you know, enjoying enjoy your retirement with coffee on the balcony or something along those lines. You need to be careful of the verbiage that's used. So for instance, this, bedroom downstairs could be used as a playroom for the kids. Enjoy your retirement on the patio. Anything like that could be considered discriminatory or against fair housing because you're explicitly kind of trying to market to a specific category. So instead, you want to use kind of vague verbiage or factual information. Um, functional floor plan that will suit, all households, whatever. Anything that you're saying, you can still paint the picture, but it has to be that anybody could enjoy this room downstairs. It can't be just for the kids. So just keep that in mind when you're writing descriptions for advertising. One thing I actually didn't really think much about is postcards. So, sending out postcards, you need to be mindful of what's called an ordinary reader test. So, if there's no preference apparent to the ordinary reader, meaning somebody who wouldn't necessarily be looking for specific violations, um, so the example given, which I know a lot of agents will send these out, is I have a pre-approved buyer in your neighborhood. As an agent who works in this neighborhood, I know how great it is, and I, would love to sell them your house. That on its face is fine to send out. You just have to be really careful about what you're saying about the neighborhood. So you can just, again, be vague or factual, that kind of thing. But you can send those out with the exception of just trying to generate listings when you don't actually have a buyer for the neighborhood. If you're just sending that out in a hope to get listings saying that you have this buyer, that could be considered false or deceptive or misleading in terms of advertising. So you want to be really careful with that. Same, just postcards do apply, obviously, to this rule as well. And they have a little bit, I would say, larger reach because the people who don't have social media are going to be seeing those as well. I've seen this a lot lately where people put like Amish built, or something relating to that. Sorry, I'm gonna. And that is also something that you cannot advertise as it is a religion. So they're a protected class. So one of the questions on the legal hotline that I found interesting and relevant were if the seller tags a real estate broker on social media. So let's say you have their property listed and they are, wanting to promote it on their own social media. I'm like, we have this really great yard for the kids and the dog and all the things. Um, and they tag you in it. The question was, can you get in trouble for that, even though you weren't the one writing it? So really you would want them to either update the details or have them untag you for sure. But if they do update the details, just as a reminder, they did sign an exclusive right to sell with you, so they should still kind of be abiding by the fair housing guidelines as well. They are not immune from getting in trouble either. Um, so if I guess heading it off at the pass is probably the best thing. Like I encourage you to share it on your socials, but share my post, or I can provide you with some verbiage to include in your post because you do want them to tag you. You want more visibility, but you also don't want to lose your license over said visibility because of something like that. Another one that I think comes up quite a bit are condos and service animals. So the Fair Housing Act does protect the rights of people with disabilities, hence the service animal. They do require generally that they make an exception for people with service animals, and it should not take into account the breed restriction or no pet policy. Um, there should be some sort of reasonable accommodation made. However, best use of this is if your buyer needs a support animal and you're unsure whether the condo association would allow this, it would be best to make it a contingency within the offer that it's contingent on the association granting reasonable accommodation by a specific date. Um, so you can say, this offer is contingent on the buyer determining if service animal is um, permitted, by April 11th. And then if it's not permitted, the offer, can be deemed null and void at the buyer's choice. So just getting that added layer of protection and not making the assumption that it would be allowed just because it is a service animal. Sasha, do you have a question? Okay. Per usual, I'm done very quickly. Um, I was hoping maybe we have more discussion, but is there any specifics or questions or anything that you guys want to chat through?
I had an agent. I was very minimally explaining fair housing. And the agent was like, well, from the buyer side, I don't have any liability. It would be on the seller side for love letters. Um, I understood his like reasoning to think that, but I
Hmm.
just still told him like let's not.
Hmm.
But what are your thoughts on that? Like, being that if the buyer writes a love letter and if we're not supposed to advise on those, does that liability still fall on both buyer and listing agent, or just the listing agent for if the seller were to use that?
I think if he's instructing that they want you to present that as part of the offer, then we have to present it as part of the offer and just letting the other agent know that the buyer has instructed that we send this over. I think especially with the market the way it was and still kind of is being as competitive as it is, I think some of that kind of went by the wayside because these were the like ways people were trying to have some sort of an edge and be more of a human versus just numbers on paper. But I think it's now time again to be much more careful in sending those out. And I have a lot of people who ask if they should be sending them out or not, and I just say, the best way to get it is to make it a strong offer. And we can write, how strong you are in the email we send over and show like, hey, this is, their strong buyer. Here's who they're pre-approved with. We can paint that case for you without presenting a letter. Does that make sense?
It does. Personally, people, oh, I always heard, or somebody I know wrote a love letter, and then they just insist. I think this particular agent could have just been wanting to be argumentative, but saying
Yeah.
that, um, well, if they write it and it has those things in there, I'm off the hook because it's on the seller.
Yeah. I don't think that's true, and I wouldn't suggest it if I were that person. Like I wouldn't run with that.
Yeah, okay. Because like I said, I see where his logic was, but yeah,
Yeah.
I told him not to rely on that.
No, I wouldn't. I mean, it's really about making sure you're protecting yourself and your license. And when it comes to that, I mean, that's a very gray way of thinking about it. And I just don't think it's a safe way to think about it. So, okay. Well, if there's nothing else, those are the main points that we hit kind of on a regular basis. So I thought I would just touch on those. And if there's nothing else, then I can let you guys go.
Yeah, I'm gonna make a post about this. I want you to know ahead of time.
Okay, sounds good. All right. Bye, everyone.